The proceeding will start shortly. The proceeding will start shortly.
Good afternoon, Secretary of State, and thank you for appearing to give evidence today. You last appeared before us in June 2023 when we questioned you ahead of the return to Commons of the Retained EU Law Revocation and Reform Bill. Proceedings on that bill resulted in the report that we would like to discuss today, and we will be questioning you on the progress you're making on the reform of retained EU law, which is a very important issue. We explained our concerns to you regarding the type and pace of retained EU law reform by way of letter on the 24th of January. These concerns summarise as follows: an apparent change in the reasons for retained EU law reform, the absence of reforms for the period covered by your report, an incomplete picture of the policy areas covered, and a lack of clarity on the mechanics of retained EU law reform. I'm sure in due course you'll come back to us on these points. And for those watching at home, would you mind briefly explaining your ministerial responsibilities, including those relating to retained EU law and Brexit opportunities? You have two officials with you today, one of whom I've met before, Chris Carr, and Gavin, Lambert. And if you could be kind enough to introduce yourselves and your responsibilities after the Secretary of State. Okay, so you'd be kind enough to, I think, introduce yourselves. Chris Carr, first of all, if you wouldn't mind.
Not at all, Mr. Chairman. Good afternoon, ladies and gentlemen. My name's Chris Carr. I'm the Director for Smarter Regulation in the Department for Business and Trade. My responsibilities include the overall monitoring of the government's rule reforms, along with the better regulation framework and our cross-cutting work on regulators. And
Mr. Lambert?
Thank you. My name is Gavin Lambert. I'm the Director General for Competition, Markets and Regulatory Reform at the Department for Business and Trade. So my portfolio includes Chris's work. I work in a job share with my colleague Caleb Deeks, who I think was at the last of these sessions last year, as well as the Better Regulation Programme and Smarter Regulation that Chris has talked about. I also cover work on labour markets, competition and corporate governance.
And Secretary of State, how would you describe your overarching responsibilities in relation to the whole project of retained EU law?
So, as Secretary of State for Business and Trade, I look after mainly industrial policy as well as related areas such as the Post Office, trade policy, and I happen to look after the programme for retained EU law because this was something that travelled from the Brexit Opportunities Unit in the Cabinet Office when Jacob Rees-Mogg moved into Bays. And because the work had already started there, it ended up staying in my department. And so what we are doing now is merging what my department would be doing in terms of regulatory work with the work of Brexit opportunities, because there's a significant overlap. So I look after what we now call the Smarter Regulation Programme that takes into account the retained EU law reform work, which we brought in with the Act, as well as better regulation and just looking at the whole regulatory landscape.
But you appreciate from what we've said in the past that we are deeply concerned and even disturbed at the lack of coordination and the lack of coherence. And in part, that may be an accident because you inherited something which actually, by some accounts, should be run by somebody with full authority within the Cabinet, in the nature of being a czar, in order to make sure that everything is done across the board, and then the Cabinet Office would come in as well on that footing. So I appreciate that you are primarily business, trade and industry and so forth, but actually this retained EU law issue is absolutely fundamental to the future of a post-Brexit Britain, and that causes us concern that you have inherited something and that the degree of coordination that's required does not seem to be producing the right kind of results at the moment. But let's get into the questioning and we'll find out the answers. Okay. And first of all, I'm going to invite Andrew Jenkins to open, because she's got an important question to ask about the laws.
Thank you. Thank you, Chair. Secretary of State, in June 2022, the Retained EU Law dashboard listed a total of 2,417 pieces of Retained EU law. In January 2023, the Minister for Industry and Investment Security said, "I should be clear, at the moment the figure we have identified and verified for EU law is 3,200 and we expect it to be 4,000. Today the dashboard shows 6,757 pieces of assimilated law. Are you confident that the current total is accurate, or should we expect a substantial increase further?"
I'm confident that the amount that we've given is what we have found. This is one of the things which I believe I said previously at the Select Committee and on the floor of the House, that it's a very dynamic process. We are continually finding new regulations, but because we had a hard deadline to get the Act through by 2023, this is one of the reasons why we wanted to make sure we knew exactly what we were letting go of and what we were keeping. So I think the initial stock, we said, of EU law that we looked at was 55,000, of which we found these amounts, 2,000, 4,000, etc., the ones specifically pertaining to the UK. And we'll continue to keep looking. There might be some things that may end up having some impact, but it's reducing significantly. So,
do you think it'll increase further, though?
So far it has. I can't. It's one of those unknown unknowns. It might do. I can't imagine that there will be much more. If you look at the amount that we are finding, it is reducing significantly with time. So since the end of last year, it hasn't been that much. But I wouldn't be surprised if we will continue to find new bits of retained EU law.
Minister, do you think people feel let down? It's nearly 8 years on since voting for Brexit, and we still have, as we've seen, nearly 7,000 pieces of EU laws given in their lives. When can we expect to be rid of these laws?
No, I don't think people feel let down, and I say this as somebody who voted Leave myself. The purpose was to be able to forge our own future rather than just specifically on where regulations originated from. My view is that it is not whether or not law originated from the EU that makes it good or bad. It is whether it is something that we want on our statute books or not. So I haven't had anyone writing to me saying that we just want EU law gone. People make specific requests, some of them pertaining to retained EU law, some of them not. So we look at it from a needs basis rather than an origin basis.
I mean, I'm looking at it from a constituency basis because I've got a Brexit seat, and I have a lot of people saying to me that they feel, 8 years on, why we're still being governed at all by the EU. So that they want confidence, Minister. So,
well, I think you can reassure them that we are not governed by the EU. There would have been laws which we put in place ourselves when we were in the EU, laws which we wanted. We're obviously not going to get
we have a timescale when you believe.
If I may, we're obviously not going to get rid of the ones we want to keep. We have said that we expect to remove about half of them or reform, but if we are going to reform them, we can't get rid of them because then we need to do new primary legislation. So the timetable, Chris, you'll probably remember exactly where we are in terms of the timetable, but we did remove the most critical thing, which was the supremacy of EU law by the end of 2023.
And just before Chris comes in, if I may, you did mention 55,000 laws. I think you slightly misspoke there. I'm not quite sure. I'm not criticising, but I do think that you may need to put the record straight unless you meant 55,000.
We did mean 55,000.
We did, Mr. Chairman. That's the number of instruments on the Eurolex database that were copied across to legislation.gov.uk on Brexit Day. Most of them are not applicable to the UK, which is why the amount of rule is much smaller.
It's just simply that we want to differentiate between the EU
Yes.
law as a whole. And by the way, just for the record, because you may need to come back on this, I think I'm right. No, I don't think. I know I'm right, because I checked Eurolex myself on the question of how many laws we've escaped by not being in the European Union, and on a reasonable calculation, which is not precise, it's something like 7,500 laws which we have not had applied to us because we've been out since we left the European Union. Was there another question?
No, that was fine. Thank you.
Good. Okay, well, in that case, we'll move forward. Now, Greg Smith, we have a slide system about to appear. Here it is.
It's full COVID-era throwback.
I'll leave Greg to take us through this.
Thank you, Chairman. Secretary of State, as a committee, as the Chairman's already said, we do have concerns about how retained EU law reform is being coordinated across government, not just within your department, but across government. And the seemingly large variance in reforms your recent report shows between those departments, which we have taken the liberty of illustrating on the screens in front of you. Now, clearly, there is always going to be a variance in terms of the number of retained EU laws between departments, because a department like DEFRA is always going to have a lot of agricultural and chemical and water regulations in a way others don't. But how much of an assessment across government is there to answer the question, well, how significant are the 71 in the Home Office, for example, which, and I know the Chairman's going to come back to the impact of that retained EU law on some of the laws around immigration policy. How clear across government analyses of the significance of those variances?
So this would have been done right at the point when the dashboard was being put together. Departments themselves would go through the list and explain whether this was something that they wanted to keep, whether it was no longer necessary or could be reformed. But the point you made right at the beginning is absolutely correct. There are some departments who, through their very nature, you look at things like the habitats regulation and so on, DEFRA being a classic example, they just have just a large ratio compared to others. So we are going via a demand-led approach in terms of what needs to be removed. What are people asking for? What are the innovations that business wants to look at? What are the things that are costing money? And that I think determines the priority. What is actually feasible? But overall, the thing that determines how much a department is revoking is whether or not they believe that this is something that's right for them, but also whether it's something that Parliament wants or would weather. So for my department, for example, the biggest challenge that I have in terms of reform is that previous Secretaries of State had said that there would not be any changes to workers' rights, certainly in terms of a reduction of rights. And that's something which I think it's important that we stick to. If we make promises on the floor of the House, we stick to them. But that immediately reduces the scope for what can be done. With DEFRA, I know that there were similar commitments made around environmental regulations. And so I think that explains sometimes why some departments have a lot more. It's also about what Parliament wants to do in terms of reform as well, not just government.
For the clarity, the chart, call it what you will, on the screens at the moment is up to date as of Monday. So this is existing non-reformed retained EU law by department. If we can perhaps just change the emphasis ever so slightly. In terms of retained EU law reform, the chart there clearly showing not insignificant numbers in many departments still on the statute book. Why does your report not show any reforms having been completed during the last 6-month period for the Home Office or the Department for Housing, Levelling Up and Communities, departments that, as that slide shows, still carry quite a lot of rule?
Yes, I think that this was one of the questions which I had previously. It all depends, for example, on where the Secretary of State for that department puts their priorities. Sometimes some things have been put through, but they haven't passed the floor of the House. So not everything goes through the SI programme. DLUC, for example, put nutrient neutrality via an amendment that didn't work. It was voted down. So it'll be reasons like that. I think we have some detail on DWP, but can you expand on that, Chris or Gavin, in terms of what's happening with those departments?
So I understand that on DWP there is work in train, and they're proposing to consult on it during this year. So the reforms are in hand, but they will take longer to come. Similarly, in the Treasury piece, there's 809 pieces of rule there, a number of which I gather are swept up as part of the Financial Services and Markets Act, which attained royal assent last year, but the relevant SIs won't be rolled out until this year. So it's not that things haven't been done, things are happening, but it takes longer to deliver some of those.
Secretary, are you confident, as the member of the Cabinet ultimately responsible for the whole programme, even though a lot of it doesn't sit under your own direct decision-making, that every single department across government has a clear plan for the revocation of unnecessary retained EU law and the assimilation into common law, where you want to keep that regulation? And what KPIs is your department putting on other departments as the lead department to ensure that they are actually delivering it and that things aren't being allowed just to drift?
Well, one of the things that we need to ensure is that we're not using linear measurements. The number is not related to how well a department is doing. If a department has said it's keeping some regulations, simply bringing out the numbers again isn't going to change. It's not going to change the end goal. We said we're anticipating about 50% by the end of 2026. So, from my perspective, we are on track. I can only go by what departments tell me. But things change. Regulations go to the House, they don't get passed. The departments might have different priorities in terms of which of the regulations they would prefer to look at or which reform program is actually going to deliver. So I don't think that the program in and of itself is losing importance or is losing priority. But I just think that as you get to the end of a parliament, there's a lot more stuff that needs to happen while the resource stays the same. What I would point to is the Star Chamber process which we have, and that is when all the departments come together. Quite a lot of it is coordination between different departments, and I can give dashboards, I can have metrics, but I cannot make departments do things that they don't want to do in the same way that another department force me to reform something if I don't think it is right, unless it gets escalated to a different decision by the centre, by number 10. But in terms of where it is we think we can make differences, not everything is going to sit within the retained EU law programme. There will just be some new things that occur that have got nothing to do with retained EU law. Our aim, as much as possible, is to make the UK competitive. Getting rid of retained EU law we don't want is just one way of doing that. We have our better regulation programme, we have the work that we're doing around regulators. Looking at all of those things together shows the emphasis that we're being put that we're putting on this. But my job was to make sure that the bill got through the House. We've done that. We've gotten rid of the supremacy of EU law, and we have till 2026 to continue removing the things that we don't want. So from my perspective, that is going well.
So the final question from me is, you mentioned the Star Chamber there. We're very familiar with Star Chambers around this horseshoe. What other official level structures are in place? If I think back to my local government career when I had a council cabinet job, the things I wanted delivered were on the top or the second item of every agenda in every meeting with those officials. Is that happening across the whole civil service, across every department, where the structures are in place at that official level to be challenging retained EU law by department on a regular daily basis, as opposed to we'll think about that when the deadline comes in 2026? Is that happening?
Yes.
Yes, it is. Excuse me. I run a cross-Whitehall board of officials, which meets monthly. My team engage on a daily basis with other departments. We have just compiled a list of 200 pieces of rule that are due for reform this year. We are working on a daily basis to help departments get collective agreement to reforms that they can then announce.
And that's definitely happening in every department?
Yes, every department is represented.
Ms. Lambert.
So I think the numbers here, as I understand it, this is the total picture of retained EU law on the stocks as of the 1st of... the total picture of retained EU law we're aware of as of the 1st of January this year. Of that, around a third has already been reformed or revoked. So this is the baseline, if you will. The numbers there don't take out the things that we've already reformed and revoked from that picture. I may have misunderstood your interpretation of it, but this is not the retained EU law. This is yet to be touched.
Okay, I'll hand back to the chair.
Mr. Jacks, you wanted to ask a question.
Thank you, Chairman. We hear sometimes that there's a reluctance to dispose of the EU law in various departments by officials. Is that true? And why can't we turn all EU law into British law? Yes, we might want to keep some, but it becomes British law without the EU name as such. It's our law. That's why we left the EU. Why can't we do that?
So it is our law. I think that's something that I can say that hopefully will provide some reassurance. That was what the lift and shift that we did with the Withdrawal Act was. We're the ones who choose to identify it as originating from the EU. But if it is something, and I'm sure we had some examples, didn't we? If it's something which we want to keep, it's just UK law now. I think naturally we will just stop talking about this as retained EU law. It's just the law of our country. The big thing that really made the difference was removing the supremacy of the ECJ. That was the thing that was really the European law still applying in the UK, and that stopped on the 31st of December. In terms of do officials stop things from happening in terms of reform, at the end of the day, ministers have to make decisions. There are always people who have different reasons, and they will provide advice. But ministers need to make that call. So yes, you might have officials saying that, well, we probably shouldn't remove this, or we probably should. It's the minister who takes the decision. I haven't personally seen any obstruction from the Brexit Opportunities team or Smarter Regulation team that are under me in terms of making sure that we carry out this programme at the highest priority. I think that if there is anything that is slowing things down, it is the attention of ministers to crises and MPs as well, as we're in an election year, onto things which are more retail electorally. So talking about, if I bring out a technical regulation, which I think is going to do something around, the media industry, for example, it's not the sort of thing that catches fire. It's not doorstep politics. So I think those sorts of things mean that it falls in salience. But in terms of the work that we are doing, identifying, yes, that is still going at pace.
Just lastly, on DEFRA, 900 laws we've kept. I would love to see that list. I really would, as would all our farmers in this country. I guarantee at least half would release the farming community and learn to get on to what we all want, which is to produce food.
Absolutely. I think you're right, but farmers, I have a rural constituency as well. Farmers are often at loggerheads not with civil servants, but with other vested interest groups who push for other regulations which they want as well. Quite often, it's farmers versus the environmental lobby, and that's where the tension is, rather than between officials or between ministers. So the nutrient neutrality example was one where we think, as a government, that's why we put that amendment through, that this is stopping us from building homes, that actually the risk is quite low in terms of pollution, but that didn't pass the House of Lords. And I know that we have colleagues, I speak on the government side, who are very nervous about anything that encourages house building. So the EU retained law programme hits the natural tensions, which we already have in Parliament as well, between which reforms we actually want. I think we could spend more time on debates on this, actually, in the House, so we can flush out what people really think, rather than leaving it in departments, because I think that will bring a little bit more clarity and transparency in terms of what we really want to reform, rather than a big bucket that says EU law, but the specifics aren't that obvious.
Thank you.
As Greg Smith asked just now, a number of questions, and said that I'd come in on the Home Office front. I am going to do very strongly. I'm baffled as to why it appears, and I'm open to correction if you can make it clear yourself that I'm not correct, but I need to know the answer to this question. it appears that there have been no reforms within the framework of the Home Office to retain EU law, and this is incredibly important because it relates to the competences under the existing consolidated treaties of asylum and immigration law. And anyone who looks at the consolidated treaties can just look at the index, can look down, and they can see the number of the laws relating to asylum and immigration which are embedded in the consolidated treaties. That is retained EU law. Now, I really want to have a straight answer to this one, and I want to know, because I've made inquiries amongst Home Office ministers and also those associated with the law officers, etc., about this question. Can you give me a categoric assurance that the Home Office is actually making changes in these interdepartmental committee meetings that Mr. Lambert and Mr. Carr referred to? Do you have the Home Office sitting there? Have they explained to you, for example, the connection between that part of the Rwanda judgment, which caused so much of a problem for the government? And are you aware that one of the claimants' cases was dismissed? Did you know about that? Did you know that it wasn't a clean sweep, that the President of the Supreme Court identified one claimant, an Iraqi, who was told that he would not be able to succeed in his claim, and the reason for it was very clear, and it's set out in paragraph 144 of the judgment itself, principle of legality. And it was a combination of an Immigration Act of 2020 combined with retained EU law, the effect of which was, in summary, that the basis for his claim was undercut, and therefore he had his case dismissed. Are you aware of that case?
No, I'm not familiar with. I'm not familiar with Home Office cases. I look purely at legislation, the dashboard regulations, and which areas.
Which in a way is answering my question at the beginning, because coordination of matters of this kind, immigration issues being near the top of the political agenda, does mean, as far as I'm concerned, and I suspect the members of this committee as well, therefore to raise the pitch of the question of whether or not the laws that are being applied in the field of immigration and asylum, as we speak with the Rwanda bill about to come back to the House of Commons next Monday, is the law on immigration and asylum being treated in the context of retained EU law seriously? You don't know the answer to the question which I put. I understand that it hasn't really become a major issue, and yet it became an issue for the Supreme Court in dismissing this claimant, because the law was clear and unambiguous. The claimant did not have a leg to stand on, and therefore his case was dismissed. I want to ask Mr. Carr, you speak to us about these coordinated meetings. Has the matter which I've raised been raised at those meetings, in all honesty?
Do you mean that specific case, Mr. Chairman?
Yes, I do.
No, we haven't gone into that sort of detail.
Doesn't it surprise you? Because after all, that was one of the most important Supreme Court judgments recently.
Well, what I would say, actually, is that the very first cabinet meeting that I had on retained EU law, when we were deciding, or certainly cabinet committee rather than cabinet itself, we were deciding whether or not to use the schedule approach. One of the things that the then Home Secretary talked about was just how little retained EU law there was in the Home Office to begin with, and they would only be reforming maybe about 40 or so things, that because historically this was an area which we guarded very carefully. So my understanding will be that if there are things which are on the books which are not being reformed, that is because the Home Office has chosen not to do so, and they don't have any desire to make changes in this area. But when you wrote to me on, well, I'm not familiar with the case, you wrote to me about this Rwanda judgment, and I did investigate. And what I was told was that the Supreme Court judgment in the Rwanda case focused in part on the interpretation of Immigration and Social Security Coordination, which was an EU Withdrawal Act 2020, and specifically whether that removed specific asylum-related EU-derived rights at the end of the transition period. But this was not about whether it was reform, but about the application of the 2020 Act. So it was a matter of law and policy and not one which we would have been looking at. So we don't know about the case, but we wouldn't have expected to have been looking at that specific case in those circumstances.
Well, may I put it another way? Could you please go away after this meeting and write back to the committee giving a better explanation as to what the relationship is between retained EU law and Home Office legislation? Because we're going to get to the bottom of this one way or another. Immigration and asylum issues are at the top of the political agenda for all countries. And if there is law which is currently embedded in the consolidated treaties by way now of statute, but the supremacy of EU law has now been eliminated, we are free to make changes to those pieces of legislation. And what I'd like to have from you is a letter clearly identifying what laws are still in place and the extent to which they impinge on current Home Office immigration and asylum policy. So have I made myself quite clear?
So I'm very happy to do that, but I suspect that the only satisfactory answer that you will get will be from the Home Office itself.
Well, that's the point.
Yes, we
This is exactly the point I made at the beginning. What is the coordination? Who is making the real decisions? And if there is a reluctance in the Home Office to make the changes that are necessary, we demand to know why.
That is something which we can ask, but the policy knowledge doesn't sit with us. So we have to take their word for it. We are not experts in Home Office policy. And if we end up doing this at this level of interrogation, we won't be able to look at the reforms in our own department because we still have our own department's work to carry out as well. And I think that the fact that I'm the one who has to answer all the questions on retained EU law actually takes the pressure off other ministers because they think it's someone else's problem. So I can ask that
on them as well as on you.
Yes, but I'm not the Prime Minister. All I can do is ask them questions and get an answer. I can't make them do anything.
Well,
and I will.
The Select Committee Secretary of State, I can tell you, and I think people know enough to know that I don't stop when I've got going on a subject which I want an answer to. So I'll leave it at that. What I am saying to you, after Mr. David Jones has asked his question, that this is a matter which does need to be clarified, it needs to be understood, and we need to have an answer to the question. And if in the Home Office there are people who are reluctant to make changes to immigration and asylum law in line with the requirements in the national interest of the United Kingdom and in relation to this very highly charged issue of immigration and asylum, we want the answers, and we want them clearly set out. And I don't care whether the letter is 1 page or 5 pages. I want it set out in a way that makes it absolutely clear what's going on. Have I made myself clear?
We can write to the Home Office and we can pass on what they tell you, but we cannot influence the content of what that letter is.
David Jones.
Yes, just briefly, Secretary of State. This responsibility resides with you. As an accident of history, really. Your predecessor took it on after he moved to your department, and he had previously been in the Cabinet Office dealing with this. It does seem to me that you've got enough on your plate generally, concluding free trade agreements and so on, which you're obviously very heavily involved in, without actually dealing with this sort of stuff. We did suggest last time, and you've touched on it today, that maybe we do need a dedicated individual, preferably a minister, a czar, whose sole focus is on dealing with this issue on a cross-departmental basis. And it does seem to me, in all fairness to you, that, really this is a piece of work that you shouldn't have been lumbered with. Has it ever been suggested that a dedicated minister should take over this?
Yes, it has. Yes. Well, I suggested that this shouldn't sit with the Department for Business and Trade, but this was an argument that I lost with the Cabinet Office, and I think that probably, and I can understand this, having somebody who voted leave looking after this would show people that this was something that wasn't being treated as a lower order priority. So I did.
So few ministers who voted.
Secretaries I don't know, but certainly at the time that the MOG change was made, that was something that was. It also has to sit somewhere where it makes sense. But I did ask for a minister. You may remember the Earl of Minto was working solely on this, and then after the last reshuffle, the MOD lost a defence minister, and they needed a minister urgently, and that's where he has gone. So we have a challenge in terms of just the number of people who will do this. Not many people want to do it, and so and that is something that is outside my control. So for now, it sits with me and Lord Johnson and Minister Hollenrake, between the three of us.
I was Minister of State at Dexter when this process began. And we were at the start of this process of identifying retained EU law and deciding what we wanted to do with it. And we had one very senior official whose sole responsibility was doing this. And I think it's a matter of some concern that is no longer the case, and that, frankly, from replies you've given today, it appears that departments are making their own assessments as to whether or not they want to retain EU law, how much of it they want to retain, and how quickly they're going to go about it. And you, frankly, are the fall guy who are coming here today, having to answer questions in which you say in response quite reasonably, well, this is not my pigeon, it's the responsibility of the Home Office or whatever. To summarise, surely you could make representations to the centre that there should be a senior minister whose sole and dedicated function is to deal with this issue of retained EU law on a cross-departmental basis. And I would hope you'd agree that was a sensible approach.
Well, that was certainly what we had previously. I don't see myself as the fall guy. I see this as a much bigger strategy. It's not just about EU law. It is about just doing regulation better, smarter regulation, better regulation, looking at what the regulators are doing. It's not all about the legislation. But also, we have a team, so it's not just ministers that look at this. Chris and Gavin are running teams of people who are looking at this. I think I would love to have a minister that's solely dedicated, and this was something that was pointed out at the point of the reshuffle. But ministerial appointments are not within my gift. But
I understand that in all fairness.
But I think it will be better coming from you, because for me it's shroud waving and saying I need. But the committee making that point would be helpful.
Are you inviting the committee to make such a recommendation?
We're doing this, as it happens, with the very positive intention of obtaining clarity, coherence and coordination, but also having it focused with authority through the Cabinet in a manner which will produce the right results. Because we need to move on from this subject at the moment, there is also the question of economic law. And the question of whether or not, and I don't know whether any of you can answer this question, and that is there any retained EU law in the field of economic law such as used to be contained or is still contained in the Maastricht enactment, which went through all those years ago in the early 1990s? Because every year we used to have a debate about what we call the Maastricht economic criteria. Now, I do not know, and maybe you can tell me when you've investigated this, and this is an opportunity to raise the question, whether matters relating to the OBR, which are at the heart of economic decision-making at the moment, are connected in any shape or form with economic criteria which was prescribed when we were still in the European Union. I know for a fact, because I took quite a prominent part in the debates over Maastricht. And I distinctly remember year after year we used to have a debate on what was Section 5 of that Act. I just want to put this on the table, and I would like a letter back on this issue as to whether or not there are any other matters of economic law which are derived from the EU, which are still on the statute book.
We can investigate that.
Thank you. Right, Gavin Robinson, please.
Thanks very much, Chair. I think it would be helpful, Daniel, if we could have the slide back on. Secretary of State, good to see you again. The previous one, the colourful one, like a bit of colour. Secretary of State, you know this dashboard. You've seen it if it reappears. Is that the sum total of the efforts of Whitehall?
Is this the sum total of the... do you mean in terms of what we're reforming or what we found?
Either. You explain what it is. Is it the sum total of Whitehall, all departments within Whitehall?
Right. This was last time we looked at this. This is what we have discovered. This is not the list of reforms or revocations.
Do you think there are any glaring omissions?
I would.
Mentally.
I wouldn't be able to tell from that graph if you mean looking at the graph specifically, but if you mean generally, no. We've gone through the dashboard. It is public, but we are always open to hearing if there are things that people think we may have missed.
So there's no representation there of the Northern Ireland office, the Scottish office, the Welsh office, and that's before you consider outside of Whitehall any of the devolved regions. So I'd be keen to hear from you, if you know, why that's the case, but more importantly, give us an estimated volume of the assimilated laws that are in place across the devolved regions.
I think that the reason why it's like that is because most legislation sits with the policy making departments. So in terms of retained EU law, you wouldn't have a Scotland law that was made by a Scottish law that was made by the EU. So it's just it's a structural thing.
So the purpose of this, as you know, is to publish following endeavours what laws that are assimilated EU law that are retained within this country, what they are, whether there have been efforts to reform them or not. So how on earth are you or His Majesty's government keeping a handle on the laws that apply within the United Kingdom, the distinctions between them? How can we publicly discern when Scotland has a very principled position to say that they will legislate in keeping with EU law, where that arises, and what disharmony that will create on the border at Hadrian's Wall, which will now have legislative challenges between Scotland and England? Of what benefit is a graphic like that when it takes no account of the differing context throughout the United Kingdom?
So the reason why we wouldn't cover those specific issues is because those are the responsibilities of the devolved administration, so they don't sit with me.
Sorry, this contains information, most of which doesn't sit with you.
No, this information sits with me.
On behalf of government, and government has devolved responsibilities, it has English responsibilities from your perspective, but our government is a national endeavour. This includes reserved issues, and this includes UK-wide issues. So I suppose my question again is, what utility does this have when it doesn't demonstrate in any way the disapplication of EU law in the devolved regions, the material considerations within the devolved regions, or how they interact with England?
So a lot of this work is done at official level. So I'm happy for Chris to provide some of the detail of how we coordinate that.
Certainly. The first thing to say is that the reason that the territorial offices don't appear on this chart is because they don't own any retained EU law. There is retained EU law owned by the devolved administrations, and as the Secretary of State has said, it is up to them what they wish to do with it. So my programme focuses on UK rule and does not attempt to reform or track reforms in the devolved administrations. Having said that, we do maintain a regular dialogue with the devolved administrations. We talk to them on a weekly basis, my team does, so we know their views on retained EU law reform, and of course when we are delivering or encouraging departments to deliver UK-wide reforms, they're obviously very interested in the impact that those will have on their domains.
I suppose practically, can you consider the utility and the benefit of having devolved administrations, devolved regions represented in this dashboard in that way, so that it is clear and demonstrable where the issues lie within this United Kingdom?
I see. If I've understood the question correctly, it's could we add figures or items to the dashboard for devolved retained EU law? If I may write to the committee on that matter, I'm very happy to consider that.
That's a practical question which I ask of you respectfully, but Secretary of State, you're a Conservative and Unionist minister within a Conservative and Unionist government. that represents the entirety of the United Kingdom. Within that umbrella, there's devolution. There's no doubt about that. But you are part of a government which brought forward a referendum, which attached to the entirety of this United Kingdom, which was passed by the entirety of this United Kingdom, and for which there remains a responsibility. So do you politically see that there's a sincere absence of information that when we consider the entirety of this endeavour, it would be useful to have representation from the devolved administrations?
Yes, I think it would be useful to see what they are doing. But across the board, in all of the areas that I cover, I try and make sure that we don't seem to be interfering in what the devolved administrations are doing until it is very significant. Probably the best example I have is on the equality side with Section 35 in Scotland. It is that level of threshold, I think, that would, beyond the usual sort of partnering and working together on something like this, I think very sensitively would not want to be looking like we were making them do things that were not their idea. But if it is providing information and collating it on their behalf, I think that is something that we can do for the next report.
I would encourage you to do so, but also see not this through the prism as to what you tell devolved administrations to do. But if you recall the exchanges we had back in June of last year, the obligations you are under in line with the UK Internal Market Act, the Office of the Internal Market, the requirements that rest within your department to ensure that you are continually testing and probing to see if there is regulatory divergence, how you address that. We know Scotland's position. Scotland's going to go and do whatever Europe does. And how that then materially impacts not just your department, but through the Office of the Internal Market, how that impacts every other department for whom, reluctantly perhaps, you hold this coordination role. That's crucially important. And that's before it becomes, as you say, on the equality side, so significant that it politically cannot be avoided. That's day and daily interference with and divergence from legislation which will cause material impact on trade within this United Kingdom. And you're the Secretary of State for Business and Trade, so that is something that's much more than just being concerned about whether you can or cannot tell a devolved administration what they can do. I don't know if you accept that, if you see that as a challenge, if you think that is something that you are going to have to consider.
Well, I think when we have the next report and we put the data to the side, then we can have that conversation. You've made the very, very correct point about what the Scottish, the SNP-led government certainly would want to do. We've only just got Stormont up and running, so this is not an area which Northern Ireland has been able to do very much, and quite a lot of the areas on the Wales side are not devolved, but they have often said that this is something which they would want us to look at and do in cooperation with them. So for the areas that are reserved, they would be captured within that. But if it's about delineating where there is divergence, I think that's something that's going to happen irrespective of whether we're looking at retained EU law. With things, if I look at issues that my department has covered, say the deposit return scheme and the extended producer responsibility, the divergence isn't always at a legislative level. It's often in terms of policy and implementation, and it's not always around, as I just said, around EU law. So I think that there's a lot that we can do in terms of highlighting that, but it is a structural challenge with devolution of where to start and when to stop.
I'd say respectfully that's disappointing again, because our discord back in June last year was that you were bringing forward a change as to how we were going to deal with retained EU law. You had scheduled laws for which you could not indicate whether there had been a UK internal market assessment, and yet that responsibility falls at your feet. That's your job. So I am concerned about that. You mentioned Stormont just being restored. I would encourage you to read the Safeguarding the Union document and understand the additional responsibilities that rest not only within your department but through your department on all Whitehall departments to be continually assessing the UK internal market and the impact of potential divergence, but not should there be and what you do thereafter. Could there be and what do you do to avoid? And that's crucially important, and the fact that I'm saying that rather than you is a further cause for concern. So I would just say to the Secretary of State, and I am interested in, I think colleagues, irrespective of their political outlook, are interested in the health of our UK internal market, then those are important pillars that you need to consider.
I think they are being considered, and one of the points I made last time was that the schedule approach actually brought a lot more transparency in terms of seeing exactly which regulations were going to be impacted and which were not under the previous style. And so that's one of the things that we have done that has been very helpful for everyone, including devolved administrations, to see as well.
I think, if I may say, before we get to the next question, that what is becoming apparent is the discomfort that David Jones referred to earlier, of your having to do something which actually straddles many other government departments and the devolved administration. Could I urge you to go back to the Prime Minister and say to him, we've been through this, we had some questions which are difficult to answer because we need to have some clarity in this very important mission of getting EU law off the statute book as and when it is essential to do so in the national interest. Could I not, therefore, and I don't want to take, I'm quite sure you're not paid according to the number of departments you coordinate. So
sadly not, yeah.
So for practical purposes, that in fact, I'm coming back to the question that David Jones raised just now, and I don't want to have to repeat myself again, and I've said it now in 3 sessions. Can we not have a clear decision by a machinery of government written answer, if that's what is required, to sort out the relationship, take some of the burden off you and give it to somebody who can be dedicated to doing the job, perhaps, I would suggest, working with the same people, but on a more focused basis, so that you don't have to be thinking about this when you're flying abroad, and you can actually get on with the job of international trade and the rest of it, and actually get somebody else to take over. And I know Lord Dominic Johnson has taken a great interest in this.
Yes.
And I can only say that somebody needs to be given the job with a sufficient seniority of attendance at the Cabinet to make sure that this does work and work properly. Because I can only say at the moment, you see from the committee's questions, we are dissatisfied with the manner in which this is constructed, with the consequence of an incoherence in the outcome, which is not in the national interest. It can be sorted out, and you've got a few months to sort it out. Could you please take that back wherever it belongs and get that question sorted? It's not specifically, as David Jones made clear, an attack on you. It's just
no, I don't perceive it. I don't perceive it.
It is a serious question of how best to arrive at the best answer, the best outcome in the national interest. And at the moment, we're not happy, as you can imagine. Now, I'm going to now move on to John Cruddas.
Thank you very much, Chair. Good afternoon, everybody. Can I raise a question about a subset of retained EU law, or let's call it British law, and that occurs in terms of the British law, or assimilated law that derives from EU legislation adopted for non-economic purposes, such as the protection of fundamental rights, and how does the smarter regulation principles apply to the reform of this body of law that strays beyond the economic issues of regulation?
Are you talking about the ECHR, or are you just talking about just the law that is...
The Charter of Fundamental Rights,
right.
Which codified rights and principles that now apply as retained EU law.
Right.
And what is the sort of overarching approach to that, which strays beyond the question of regulation and economic?
So we, certainly before my time, but under previous Secretaries of State in this role, there were parameters that were given about what we were seeking to do. So that's the example I gave earlier about environmental protections, workers' protections. What we were seeking to do was to make the economy primarily more competitive, but areas where we felt that we wanted to do things differently, providing an opportunity to do so. So they do fall mainly in the economic space with product safety. Do we want a UKCA marking? I haven't seen, I think I might need some examples. I haven't seen an example of something like a right which we decided we didn't want to have. And quite often, when I'm asked about these things, I remind people that when we were in the EU, we were making some of these laws ourselves. So just because it happened while we were in the EU doesn't mean that we want to get rid of it. And they should be demand-led. It should be individuals saying this is a problem or businesses saying this is a problem, rather than something which ministers decide, well, I don't like this particular thing, I'm going to get rid of it. So I think that gives a very loose summary of how we are going about the reform programme.
I take that. I agree with a lot of it. It's just nowhere in this debate have I seen some sort of strategic approach to some of the civil, political, social rights that are not covered in the environmental protections, the economic rights, or the workers' rights. And just wondered if this fits in terms of the overarching strategy, in terms of is now British law.
I think fundamentally it'll be because they are not contentious. The areas that are contentious tend to sit outside what was retained EU law, what's happening with the ECHR in terms of refugee and asylum policy, and a lot of it goes well beyond Europe as well, refugee conventions, etc. But I have always started from the what is it that people want to see perspective. And I have not had representations in the social space as you've described.
Right, so we can take it from that there is no demand-led approach to these forms of social, political and civil rights.
Certainly not from what's been on the dashboard. We've put it all out there. What do people want? What do people not want? We've had lots of suggestions, that things we're looking at, such as novel food, and much of that divergence, as the Chair said, will happen anyway, simply because they will continue to regulate and legislate, and we would. But I think I would need an example to get into the specifics, but nothing comes to mind.
Not on your radar, that's fine by me.
Just before I move on to David Jones, just one other further pointer to the direction in which the committee is moving on the subject. The origins of EU law we could spend a lot of time on, but they came about, and we've mentioned in the past about VoteWatch and the work that's done by Simon Hicks and his department in the London School of Economics over the years. There are, in fact, evidence that it was done by consensus for the most part, because they didn't want a row, but they knew perfectly well when they went in the room that there would be a majority vote if there was one way or another, so it would be better to arrive at consensus. That doesn't necessarily at all make for good law, and I say at all.
Sounds like Parliament.
Not with respect to the differences between having a Council of Ministers meeting behind closed doors without even a transcript, which is the way in which these things were put through, and by consensus rather than majority vote for the most part. And on the other hand, the manner in which we make laws, as we're doing this afternoon, fully transparent and in a democratic form. So there is a difference, and therefore it's not unreasonable for people to wonder why it is that we're hanging on to laws which were made in a manner which lacked the kind of democratic legitimacy that our system, now we've left the European Union, can now do in full. So I'd leave you that on the table, because that is something to bear in mind when considering what you get rid of and what you don't, because some of it was passed because they didn't want a row, to put it bluntly. So I'm now going to pass over to David Jones and ask him to get on to another very important part of our inquiry.
Thank you, Chairman. As a visual aid again, Secretary of State, we need another slide, please. Perhaps before the slide is... there we are. You will recall that on the publication of your report, the Chairman wrote to you on behalf of the committee expressing disappointment at the level of reform or revocation of retained EU law that had happened over the last 6 months of 2023. Your report contains a table 2, which indicates that the government has made a decision to assimilate around 44% or around 3,000 individual pieces of EU law permanently. And then it gives a tally of the individual pieces of EU law that have been revoked, removed, or reformed. In 2023, the second half of 2023, after the enactment of the Rule Act, 125 pieces of retained EU law were revoked, and 22 were reformed. The chairman wrote to you, and I'll quote what he said: "Of those reforms that have been undertaken during the reporting period," that's the last 6 months of 2023, "of 26 statutory instruments, only 2 are worthy of note. The first on wine marketing and the second on working time calculations. The remainder relate almost exclusively to the correction of technical errors, consolidations and restatements for a 6-month period. This is simply not good enough." The 2 pieces of retained EU law that I've mentioned were in fact identified by you in your report as a key reform. That was the way that you put it. And on page 16, we see the start of a table. This is the second page of that table. And that's described as details of the SIs made by the end of 2023, which revoked or reformed retained EU law, amended or restated it, or made amendments consequential upon the Rule Act. Do you accept that the reforms and revocations in the second half of 2023 simply fell short and that not enough was done?
I think that this is one of those areas where we are looking at what the problems we're trying to solve are. So it isn't about the number, it's about the impact. And it goes back to the fundamental point which has underpinned all of this, is that there is actually quite a lot of retained EU law that people want to keep. It isn't about making sure that we get rid of 80% or 90%. It's about getting rid of what we don't want and keeping what we do. And when you look at it from that perspective, I don't think it is disappointing. The ones that I think will be game-changing will take time. They need parliamentary debate because it isn't as straightforward as government just saying, well, we're going to get rid of this and we're going to get rid of that. This is a programme which most of the time has been spent on the bill, but as a mechanism for legislative reform, I think that it is moving quite quickly, given that none of these are, economic priorities for any particular, for any particular interest group. These are just things which we are analysing and looking at and deciding on merit, case-by-case basis, whether we want to keep or reform.
But Table 2 of your report makes clear that you intend to revoke or remove 35% of retained EU law, and you intend to reform around 15%. So that decision has already been made. You know what you want to do. You know the course you're charting. It's just that if we're talking about 50%, which is what, by my calculations, 35 and 15% add up to, you've got over 3,000 individual pieces of retained EU law that are going to have to be dealt with. And at the rate that you've achieved so far, that's going to take many, many years. So the question is really, do you anticipate an acceleration, for example, in the first half of 2024? And if so, what sort of acceleration do you anticipate that will be?
Well, this is not a linear process.
Oh, I know, you've explained this.
But I think the one thing that we have to remember is that the second half of 2023 was removing supremacy of EU law across the board. That is not something which we can show in numbers. These are the list of regulations. That in itself was a huge piece of work. It's said in a sentence, but it's a huge piece of work. And I think that's how we should look at what happened towards the back end of 2023. I think by the end of 2024, we should have done another 500 or so. But the 6-month reporting timeline is it's an arbitrary timeline. 6 months is just halfway in between. It doesn't necessarily say or indicate how much is going to get done over the entire period. It's something that we can use as a check-in point. But I think the fundamental point about the 2023 work is that this was about removing the supremacy of EU law, and that is not insignificant.
So you anticipate that by the end of June, a lot more will have been revoked or reformed?
Certainly by the end of 2024, we'll see where we get to by June. It's not. This is not up to me. This is up to Parliament. It's up to timetabling. It's decisions that are made by MPs as well. If this was just me stripping out or erasing things from the statute book, it would be quite different. We need to make sure that we do this via the process.
Of course, you're relying on other departments too, aren't you?
Yes, that would always have been the case, irrespective of whether we have a SAR or we don't take other departments' policy work away from them.
I understand that. But if, again, and I'm sorry to sound as if I'm obsessed with the notion, but if there were to be someone with oversight of the entire process, that person would be able to coordinate and drive all the departments to proceed as quickly as possible with the exercise that you're responsible for at the moment.
Well, I suspect you would be asking them the same questions that you're asking me now. Because remember, until end of 2023, we did have someone who was doing that. We did have the Earl of Minto, a very senior corporate executive, someone who's in the House of Lords solely looking at this, and he was driving that. I don't think that there's going to be anything. I don't think there's going to be anything more pacey than that, unless you're volunteering to be a czar, and I'm very happy to propose that. And it was something that we suggested previously.
Really suggested that, Mr.
I don't think either of us. But the point is, your ambition is clearly to deal with, on the face of your report, to deal with over 3,000 individual pieces of...
Yes, that is the ambition.
And that will, at the current rate, don't you agree, take an awfully long time. So it is going to have to be accelerated very considerably.
Mm.
And if we're only looking at 500 by the end of 2024, that is not a drop in the ocean, but it's a minimal amount. You were going to...
Right, I think, so as of the 1st of January, we had already revoked or reformed just over around 2,300 of the total quantum of rules. So
I'm talking about the statutory instrument process, which is what's set out in the table that we're looking at here.
You'll correct me if I'm wrong, Chris. Of the 6757 total, we've already revoked and reformed just about 33% of that. Our ambition is to get to just over 50% by June 2026, I believe. So we have done around 2/3 of that already. The challenge remaining is big, but I think I'm not sure it's perhaps quite as pessimistic.
What is your best estimate of how long this entire process will take, Mr. Lambert?
I think we're currently working, aren't we, to the 2026 deadline of getting to...
Do you still think that's achievable?
Yeah. That's with a fair wind. To Secretary's point, we are obviously reliant on colleagues around Whitehall finding the time to do this and prioritising it and making it happen. But that's our assessment at the moment on the pipeline of plans the departments are giving us.
It's a bit worrying that you say they have to find the time to do it. I mean, somebody surely should be telling them that they've got to find the time to do it.
I think we're all conscious, aren't we, that priorities do change. Unexpected events happen, don't they? And
so you're still confident that 2026 deadline can be hit? Okay, thank you very much.
And we are also going to come on in a moment to the question of the role of organisations such as Hogan Lovells and what they're recommending. And I think I'm right in saying that we've never had an answer to the question that we put about the terms of reference. Is that right? Terms of reference for Hogan Lovells.
I think
we are slightly puzzled as to what they've been doing and on what basis they were instructed for £4 million, as I understand it. And I think if I could remind you to get that information to us, because if they were given that external job, then other people could be given a similar kind of opportunity to help to accelerate the process. That's really what I'm driving at. And if at the same time you were to find that, for example, Lord Johnson was given the opportunity to be given that job specifically as a Tsar to help to, shall we say, drive the issue forward, then you might make more progress. And I take your point that there are circumstances in which some issues, as a matter of qualitative effect, are more important than others. But if you haven't done the job of identifying what is to be done in the manner in which I'm suggesting with a Tsar driving it, we are, as David Jones has just indicated, and others too, going to find that the job is not going to be done as quickly as it could be done, nor perhaps as efficiently or comprehensively. And that's our concern, because it is a matter of national interest. That laws are not just sitting on the statute. And many members of the civil service are engaged in sitting at desks, processing individually, day by day, legislation which is on the statute book. That's what they're there for, to a very great extent. We need some acceleration, we need some concentration, we need a better outcome. That's really what we're driving at. And we are concerned that by the end of June 2024, enough progress will not have been made at current rates. That's the point. So if you could take that...
We can say a bit more about Hogan Lovells, because Chris, you can describe exactly what we've asked them to do. We can get... I was told that the contract is on Contract Finder on gov.uk, but you can describe the work in terms of, what is the terms of reference.
Certainly. We asked Hogan Lovells primarily to work with us and with the National Archives on the dump of legislative data from Eurolex to make sure that we hadn't missed any significant pieces of rule. When we hired them, we had already done a couple of iterations with departments who had proactively identified the rule that they knew about inside their department. As we now know, there were thousands of pieces of rule that were not initially identified by departments, and that has come through the work of Hogan Lovells, and they are still completing the final trawl through the sort of layers of information in Eurolex. We are confident, as the Secretary of State said earlier, that we have identified all the significant pieces. There is an awful lot of very small instruments there that amended one particular thing at one particular time, which may or may not have any ongoing legal effect, which is why the Secretary of State says we don't expect to find very many more pieces, but that is the final stage of their work.
And are we going to have that presented to us?
Yes, when they're finished, we will certainly put that in the next rule report.
And have they asked for more money since they originally agreed 4 million?
Well within budget.
Okay. Right, so next question is... Marcus Fish, yes.
Thank you, Mr. Chairman. In your letter of the 24th of January, you talked a lot about the potential for acts of Parliament to be used to deal with some of the assimilated law which has been built up in terms of its reform. I was just wondering if you were able to give us an update on what the programme is, what has been achieved in terms of Acts of Parliament, other than the Financial Services and Market Act and the Revocation and Reform Act itself to do this.
So the Procurement Act is another one which carried quite a lot of reforms. Data protection. We had a data protection. I can't remember exactly the full name of the Data Protection Act, but that's another one that's picking up reform and revoking things just by the sheer process of legislating. We are doing what we want. I don't have a full list. Do we?
It's the Digital Markets and Competition Consumer Bill, which is sweeping up large areas.
Yes, and that is so. This is how we are just regulating differently from the way that the EU does. The way that we look at subsidy is now different from what the EU is doing, and there'll be many other examples as and when we pick up different bits of legislation, I think sometimes in very unexpected places.
Right. Would you be able to incorporate this sort of information in your six monthly reports, so that we can keep a track of
where primary legislation is doing some of this work? Yes.
Yeah. Brilliant. Okay. Well, that is good.
Have you made any assessment of the value of the retained EU law process and project so far in relation to, as you said earlier, competitiveness and things like that? It may be that you yourself haven't necessarily got that answer. And I'm interested to know whether Mr. Carr has formed a judgment about the extent to which, and do by all means chip in, as to whether or not the process has produced beneficial results.
Of course, Mr. Chairman, I'm going to say that the process has produced beneficial results. The question is one.
Doesn't necessarily convince me.
The question is one of what is our counterfactual. If we didn't have a retained EU law programme and we didn't have a retained EU law act with the powers to amend retained EU law more easily, I'm sure some of these reforms would have happened anyway. What the Retained EU Law Act gives us is a set of tools to do things with statutory instruments that were not previously available, and a number of these reforms would have required primary legislation. So I think without any quantitative analysis, it is quite easy to claim that the process has delivered benefits because we've been able to do things we wouldn't have been able to do nearly as quickly.
Good. That's interesting. Richard Drax, next question, please.
When does the government's contract with the law firm Hogan Lovells expire? Does the government legal department have enough resource to continue to work at the legal aspects of the reform project on its own?
I don't have that information. I don't know when exactly it does expire.
No, I don't think I know exactly either. It is not...
In March?
Yeah, I thought it was the end of March this financial year, but let's come back to you on that. We can
end of March this year or next year?
I don't think it's this year.
Okay, I may have got that wrong. Let's
we can write to the committee with the exact details.
When it goes, do you have enough resource to continue to work on its own, the government?
Yes, well, yes, because I think what Hogan Lovells is doing is more the finding rather than the reform. They're not doing the reforming, which is the key area that we are interested in. And just personally, I am always very suspicious about getting law firms in and paying them lots of money. So this is an instinctive suspicion that I have, that we will always do things the best way if we outsource. Having it in-house, in my view, just keeps more eyes on the ball. And it is not a purely legal process as well. I think sometimes you want businesses, you want, whether it's the farmers, whether it's the builders, the entrepreneurs, the people who are constructing it, they will tell us more, to be perfectly honest, than lawyers. Lawyers can help us solve the legal problem, but in terms of reform, I would start with the businesses. And we have roundtables. We work with representative organisations like the FSB, for example, Federation of Small Business, Chambers of Commerce, and we constantly tell them, tell us what your members are saying that they need. Can we use this programme to help them solve problems? That is my preferred approach than getting more lawyers in.
So actually, we'd welcome the expiry of this.
Probably.
Yes, I would slightly question this approach, if I may, and for a very good reason, that quite often there are vested interests involved when you go out to trade organisations and you ask them when they've been used to dealing with things which they've got used to, but not necessarily on the most efficient basis in the national interest. So the equality question, I'm glad that Mr. Lambert is nodding as you are too, because it's not just being something. It's not just something which is done for the sake of it. It's got an objective, and you've made this point over and over again. And qualitatively, there are a lot of vested interests, whether it's in relation to particular trade organisations or in particular fields of endeavour, research, and things like that. So the combination of changing laws on the scale that we're talking about, in the light of how they came to be made in the first place, is a very important part of the freedoms that we get from governing ourselves, and therefore beneficial to the country in knowing that the legislation is actually consistent with national interest, and that's the key question here. So, if I could put it to you in a nutshell, will the next parliamentary report include a more sectoral analysis of assimilated law reform, which has been informed by the current approaches of regulators to their respective sectors? We want really to see impetus. We would like to see more coherence. As you gather, we also believe that there is a very strong case, even at this rather late stage in the cycle of this Parliament, for a driving force encapsulated by the word czar, whoever it happens to be, and to take some of the burden off your shoulders personally in order to be able to accelerate the process with the very able assistance I'm sure you've got at the table that I'm addressing at the moment. But can we not make more progress more quickly, more efficiently and more coherently? That's really our message. I think we will report in due course. If you'd just like to perhaps comment on what I've just said, and then we'll bring the session to a close.
Thank you very much, Chair. I think you make a really good point about vested interests. It is true that just looking at it from a demand-led perspective will mean that vested interests will try and request changes that are to their benefit. But the corollary is that there are always other vested interests who have a different opinion, and it is our job to, well, first of all, arbitrate. I think law firms are also a vested interest. They love regulation, and they will always find a way to make more of it. But the broader point about the coherence of what we're doing, we will try and bring out a bit more in the next report. But my vision of coherence was about smarter regulation. Brexit was not an end in itself. It was something that was supposed to deliver a change, not just in terms of the statute book, but also a change in culture and a change in how we think about what is right for the country, and not have ourselves in a form of stasis where everything's too difficult and the EU won't let us and so on. It isn't. Quite a lot of the bad legislation is homegrown as well. We need to just do better on the culture side as well as on the legislative side. And I think that those are some of the things that aren't necessarily apparent, but which bring together the coherence you're looking for on smarter regulation and the pillars of better regulation and what the regulators are doing, Ofgem in particular, which all our constituents write to us about in terms of how it is impacting, how their policies are impacting them. And bringing all of that together, I think, will help highlight how EU retained law is working to help improve just the entire statutory landscape.
And lastly, don't forget the points that we've made about the Home Office and the question of economic law. I want a report, please, on those two issues to find out for sure whether the matter's been properly looked at, or whether, on the other hand, there are good reasons why nothing has been done so far as we can ascertain on that front. So if you could do that, that would be more than helpful to our final report. But thank you very much for coming.
Thank you.
And I think we've had an interesting dialogue, and we look forward to hearing from you again. Thank you very much.
Thank you very much. Thanks, everyone.
The proceeding has ended. 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 The proceeding